criminal matter sent to you for a brief review. I'll call it now. Commonwealth versus Richard Stebbins. This is scheduled today for a trial assignment and final compliance selection, and Commonwealth has filed a motion for instructions to you.
Okay. All right, sir. So why don't you come over here? All right. So let's take a look here. So this case, can I see the docket sheet, Madam Clerk? Can you get a chance? Today it's on for trial assignment. You have a jury trial date of October 15. Okay. So the trial assignment date is a day to make sure and final compliance selection. How are we doing with discovery? Is all discovery been provided from the Commonwealth to the defendant?
Yes, Your Honor. I know on the last time this was before the court, it was before you in courtroom 23.
Okay.
You sent a series of dates in which the defendant and I were supposed to respond to each other.
Okay.
I did not receive any written notice of evidence the defendant that the defendant believes the Commonwealth needs to provide to him. I did file a notice of discovery that I sent and was received by the defendant on the date that I was required on August 26th. So
you provided to the defendant, and I see here a Commonwealth's notice of discovery, this list of 11 items. You sent it to the defendant?
Yes, Your Honor. Okay.
Did you get those, sir?
Yes.
Okay. All right. So, Commonwealth, you believe all discovery is complete?
Yes, Your Honor.
Okay. Sir, do you agree with that? Sounds like you've got, I don't remember the exact details. I remember that you were here last time, had some conversation about discovery, and I do remember setting dates for out-of-court compliance. So, do you agree, sir? You have everything you're looking for here?
Now that I have this, I have new problems.
Well, wait, you're looking at something else. I'm talking about discovery. Just all the information for the case. Do you believe you have all the documents and evidence for the case?
The fact that the Commonwealth withheld this information for 2.5 years.
Well, I don't know if that's the case.
I don't want anything else, and I'm not asking them for anything, and I will not request them for anything else because they had 2.5 years to give me everything.
Okay, so we're getting ready for trial here, sir. We're trying to look forward. We're right what we're doing today. The purpose of today's hearing, September 9, 1 month before the jury trial date, is to get everything ready for October 15, which is the jury trial date. Okay, so let's not look backwards. We're going to look forwards, because I do have a recollection of having what the discovery disputes, and as can be the case, back and forth. Case goes on for a while. Do you have everything? So now we're looking forwards. Commonwealth indicates he's giving you everything, and you didn't write down for the Commonwealth anything in particular that you're looking for, right?
It was already requested by my previous lawyers.
Do you have anything that you're looking for, sir? Further, discovery-wise?
What I needed, I have more than enough to prove my case.
But all right, from the Commonwealth. So have you turned over everything to them that you intend to introduce as evidence?
Yes.
Okay. So discovery-wise, it sounds like we're ready. Evidence-wise, we're ready for the October 15th date. I guess I'm wondering, do we have from the Commonwealth like a witness list? Did you provide that?
It's provided in the police reports, Your Honor.
Well, a witness list. No, not in the police report. You should write because when it comes time for the jury trial, the judge is going to say, write down your witnesses and who are you summoning in. Everybody's entitled to know who the witnesses are going to be. So,
Your Honor, I did prepare a witness list when it was previously on for trial that I can provide to the defendant now.
Okay, yes, I think that would be a good idea. Let's let him know how many witnesses are coming in, who you intend to call, and how many witnesses does the Commonwealth have?
It would be at this, I'm sorry, I'm not actually seeing it, but I can print it out and provide it to the defendant momentarily.
Oh, how many witnesses do you expect to call?
2, Your Honor.
2, okay. So you expect to call who?
The complaining witness in the matter and one of the investigating officers.
So that's who? Now's the time. There should be no confusion.
It would be Beth Nichols.
Beth Nichols, and who else?
It would be Officer Bouchard from the Warren Police Department. Let me just get his first name.
So you intend to call 2 witnesses, the complaining witness, Beth Nichols, and a police officer, and that's it, right?
Yes, Your Honor.
Okay. All right. So, to the defense, do you intend to call any witnesses?
I gave a list in the CD.
Where did you?
I provided the CD, all the information.
When did that happen? Do you have that, Commonwealth?
I do have a copy of the CD, and I do see the list. If I may address the list that was provided.
Right, because I don't see, you're going to have to provide it to the court. Sir, when you come on the 15th, it's got to be printed out. So how many witnesses do you plan to call?
It's about 20.
Well, you need to write them all down because you can't just. No, sir. The whole point of today, here's the thing. You have to let them know in advance. We don't, in Massachusetts, wait a minute. You don't tell me to wait. I'm going to wait. Listen to me. In Massachusetts, it's not trial by ambush. So you have to let the rules of discovery on both sides, you've got to let the other side know who the witnesses are, and then a little offer of proof. What do you intend that witness to say? So, I don't know if you've gone through that with the Commonwealth yet, but 20 witnesses sounds like an awful lot. Do you have the list in front of you?
I do have the list in front of me, Your Honor. It's not a blank list. I did write on it. If I may address the list that was provided.
Well, and I don't have a list either. So are you ready to address each one so we know who they are and what they're testifying about?
Sure.
Okay. So let's go through them then. Who's the first one? I don't have anything in front of me to address here, but the Commonwealth is entitled to this information, sir, so I guess we're going to do it in open court. Who's number one on your list, Commonwealth?
I have Linda Reeser on my list, Your Honor.
Okay. Who is she? Do you have her date of birth and her address?
No.
You have to provide date of birth and address.
I don't have it. My
Well,
previous
if you
lawyers
don't,
never told me I needed to do
no.
that.
Well, I'm telling you, sir, this is the thing. When you decide to represent yourself pro se, I'm not going to give you legal advice, or the trial judge isn't going to give you legal advice. So if you look at the rules of discovery, it would tell you that you have to alert the other side, the name and date of birth and city where the witness resides. Because the date of birth, they're entitled to run their criminal record, just like you're entitled to run a criminal record of anybody on the other side. And when the judge, whoever the trial judge is, goes to alert the potential jurors of who the potential witnesses are, we let them know the city that they live in. So you need to provide that.
My previous lawyers lied to me about
Sir,
all this stuff.
we're not going backwards.
Disability Act
Sir,
about all this,
sir,
I've been mistreated, the morals and ethics violations that have been going on here nonstop.
All right. We're going to talk. I see you're holding the Commonwealth's motion there. We're going to address that. But first, we're addressing the witnesses. The witnesses are first. Okay. So why don't you put that piece of paper down, because we're going to talk about the Commonwealth's motion in a minute.
I just want one witness. I only want one witness. We're going to ignore that. This Dominic Stebbins, born August 18th, 2006. He lives at 54 Hope Street. He's witnessed all the abuse that Beth Nichols' son has gone through. He's heard Beth Nichols talk about all the times the Commonwealth has covered up the abuse that was allowed to happen.
So
to
Dominic
her son.
Stebbins is you only plan to call one
I
witness.
just need one witness. He just turned 18, so now he's an adult. He was a juvenile when he witnessed all this abuse that was allowed to happen by the Commonwealth.
All right. Okay. Hold on a minute. So even though you previously gave a witness list of 20 people, today you're telling the Commonwealth only one witness,
Because
right?
I don't remember everybody else's information.
Okay. Well, you've got
the time frame that I have. I don't have to rush. I was told I needed 10 days, or no, 5 days, 10 days before trial to provide a witness list. I have until, so it's October 15th, it's a trial, so I'd have until October 4th or 5th.
I never heard that. Where did you come up with that?
I've gotten recordings of all my court dates and I put them online, so there's no misunderstanding. I was told that that's how long I have.
I don't think so, sir. That's the point of today. The point of today was to let to have a final date to talk about, get ready for the trial, so everybody's ready to go. If you're saying today you only want one witness, then that's the witness you can call.
There was a problem with what I gave in the past. Why wasn't anything said in the past? Like, this is incorrect. You can't give me this. She should have handed it back to me and said, no, this is not what the law allows.
I don't know what you're referencing.
4 lawyers. And they all lied to me. And I have it in writing. I finally started keeping things in writing. So I can keep track of all this and prove.
All right.
That I've
Sir,
done
do you want to
everything
have a jury trial? Do you want to have a jury trial on October 15th?
I want a jury trial now.
No, today's not your jury trial date.
It keeps
Probation.
getting put off. Other people had trials
Officer
today,
Levitt.
but they haven't been waiting as long as
Officer
I don't
Levitt.
understand.
Keith. Hi. Can I just see the record, please? Thanks. Sir.
I'm sorry. You're new to this. I'm sorry. There's been a lot.
I'm not that new to this, sir, because I was here the last court date. I was here the last court date, and I remember.
The ADA had created evidence and presented it to a judge. They created fake evidence. I have no confidence that I'm going to have a fair trial I don't trust anybody in this courtroom.
Okay.
That's why I started recording everything, and I won't talk to anybody in private anymore.
Okay. All right, sir. Do you want a jury trial? Because we're trying to get us ready. You're saying you want a trial.
I'm not going to speak to the Americans with Disability Coordinator because I don't understand what's going on. And
Sir,
no one will explain
you're
anything.
talking about one little motion, one motion there. I'm trying to clarify. We're getting ready for the trial. There's a number of issues.
If they recommend that I don't go to trial, then if they recommend that I don't go to trial because of what's been happening to me and the way I've been treated.
Who's recommending you don't go to trial?
When I speak to the American with Disabilities Act coordinator and listen to what they have to say, they must have some information that the lawyers have refused to tell me. And I know judges aren't allowed to give legal advice because I've tried.
Right.
And the
I'm not
ADA
sure what you're...
I don't even know her name. I haven't spoken to her. The only thing she's ever said to me is she doesn't want to be recorded, and that was like a month ago. And
well, she doesn't have to be recorded.
I've never spoken to her. I don't know her name.
Well, I think she sent you materials. You've sent her materials. So
that was just a couple weeks ago. Then this has been going on for 2 years and 11 months.
So that's why we're trying to.
And the Commonwealth is trying to cover up their crimes. And
I think what they're trying to do is head the case to trial. If you don't want to agree to a disposition, and let me just clarify with the Commonwealth, you have a witness who's available and willing and interested in testifying,
Yes,
right?
Your Honor.
Okay. So the Commonwealth is going to be answering ready for trial. We're trying to get you also ready so that when you show up on the day of the trial, we're all on the same page. Witnesses, are you set with that one witness, Dominic Stebbins? That's it? Yes? Okay. All right. So you've got that. That's clarifying to the Commonwealth, right? He's not calling the other 19 witnesses on that list. He's only calling Dominic Stebbins. Yeah.
So Dominic Stebbins' birthday is August 18th, 2006.
Yes.
And he's at 54 Hope Street. Which city?
Springfield, Mass.
Springfield. Thank you.
01119.
Thank you.
Okay. So you have that one witness, and we'll see. You know, everybody are bound by the rules of evidence in terms of what's admissible and not admissible in terms of a trial. So generally speaking, what happens at the trial is, I can see here the date of alleged offense is October 4, 2021. Generally speaking, what comes in at the trial on that type of offense is what did or did not happen on October 4, 2021. And the issue is whether the Commonwealth can prove beyond a reasonable doubt the charge that they've alleged. Generally speaking, there should not be lots of evidence about other days beyond October 4, 2021. So when you talk about lots of other things, you're going to have to pare it down to what's relevant to that October 4 date. Okay. What other, I see there's one evidentiary issue. So I don't know, in addition to whatever else. Commonwealth, what is this motion? The defendant is concerned about this. What is it that you're asking for with this motion?
Your Honor, I'm just asking for the defendant to follow the rules of court. So I know
about what?
So on previous occasions, the defendant has appeared with a dog in the courtroom. I believe that in the context of the jury trial, the presence of a dog may garner undue sympathy. So
you don't want him to be able to have a service dog at the trial?
Unless it's...
Okay, so let's even see if he wants one, because he's not asking. Normally the person who wants something out of the ordinary asks for it. Right. Sir, are you asking to have a dog with you at the trial?
I told my previous lawyers I was holding my dog when this incident happened. The only reason I was allowed to leave that house is because I was using that dog as a shield.
Do you want the dog at the trial?
Yes, I do.
At the trial. Okay, now we're going to have a conversation about why it is you feel you need your dog at the trial.
The way you people treat me is like shit. And having my dog helps me deal with that. I got my dog because you guys tampered with evidence and then coerced me into pleading guilty after I tried to commit suicide. And I didn't know I had some medical issues at the time and I was being misdiagnosed with other things. And then the Commonwealth totally ignores this stuff. You tamper with evidence all the time. Every time.
So do you feel it's an emotional support dog? Is that what you're trying to say?
My therapist recommended
do you
that.
Say that again?
My therapist is the one, and my doctor recommended that.
So it's an emotional support dog. Does your dog have special training?
She doesn't need special training from what everyone's told me.
Well, so that's a no? No special training for the dog?
No, she's not there to diagnose seizures or
so no special training.
Medical issue.
And it's not for a physical issue, it's for an emotional issue. Have you been to a doctor about these emotional issues?
Yes, I'm seeing one out. It's been made worse because of this trial. I've been dragged on for years. And that's part of this
so what kind of a doctor do you see?
I'm physically disabled. Coming here has created a very My shoulders right now, I have a knot that feels like there's a broken bone in my shoulder, which is obviously not. And I've told all my lawyers, driving out here to Worcester, I live in Springfield, it takes over an hour to get here, and I have to walk over a half mile. I have a genetic skeletal muscle disorder. Everything I do builds up. So the more I do it, if I keep squeezing my hand, the muscles die in my hand, and then it begins to overload my kidneys.
Okay.
And I get kidney damage. And I told my previous lawyers that driving out here to Worcester, I've driven out here like 20 times for no reason. Nothing was presented to me. I was just told, all right, we'll come back in 2 months. All right, come back in 2 months. I did get 2 court dates waived. I didn't have to have my appearance because I was having such horrible migraines, because that's what my genetic disorder does to me.
Do you think you're physically up? Sir, you think you're physically up to doing the trial, or are you afraid that maybe emotionally, physically, you're not up to it?
Physically, I might not be. This scar in my head is when I was talking to someone about this for hours, and then I passed out and hit my head on the corner of a shelf.
All right.
And I was lucky enough that I didn't hit my mouth.
Hold on a minute, sir. Madam Clerk, can we check with the judge's lobby, see if there's any clinician available to do a competency screening today?
I've already had a competency hearing.
Well, we're going to see what this, because you're telling me you may not be emotionally ready for it, so.
Physically ready. Emotionally, I'm ready. Physically, I have no idea
might be
how
ready.
I would be physically.
All right. Why don't you have a seat, sir? Have a seat. We're going to just see what step we can take on this one today.
Okay, do you mind zooming down to get it? We're going to do a hearing. We're going to do a restraining order. Yeah, thank you so much. Sure. So, 2169 CR 1285. Just competency.
Great.
Thank you so much. Okay, so competency screening is ordered. Right?
Okay. So what should we, because since he's pro se, is she going to, is that Laura?
Yeah, she's going to come down and grab this stuff.
And she'll come in and we can ask her where to send it. Okay.
All right. I'm just going to remember to write that on the docket. But we do have one last.
So sir, just hold on a minute. We're going to have a doctor come in and talk to you this morning, see where that gets us. Okay? All right.
Thank you. All right. We are back on the record on Commonwealth versus Richard Stebbins. For your information, Your Honor, the Commonwealth has filed a list of witnesses for the trial. I'm just going to put it off to the side for our office.
Your Honor, if I may, I gave the clerk a handwritten copy. I did print one out during the luncheon break if you'd like to have a
Okay.
copy.
Sure. And you have one for Mr. Stebbins there? Okay. All right. So we set this matter back earlier this morning to do a screening on a competency evaluation. So we have the clinician here. Doctor, can you, why don't you state your name for the record, please? Sure, you can swear him in, but I don't know if we're getting that far into it. You could swear him in if you'd like.
Do you solemnly swear all testimony given in the matter now and hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. So, doctor, can you give us your full name?
My name is Bruce. Last name is Loading, L-O-D-I-N-G. I'm a licensed psychologist and designated forensic psychology candidate.
Okay, thank you. So, have you had a chance to talk to Mr. Stebbins?
I did, Your Honor.
Okay. Were you able to do the screening, the competency screening evaluation?
I was not, Your Honor. Mr. Stebbins requested that we tape the conversation, or he be allowed to tape the conversation, and then when I told him that Court Clinic doesn't tape interviews in that manner, he asked if I could do it, and I reiterated that we couldn't do it that way, and he was not comfortable proceeding given that he has distrust in the court process.
Okay, so sounds like you weren't able to do the competency screening because Mr. Stebbins was insisting on audio recording the conversation. Is that right?
That's correct.
He wanted audio recorded, and you, it's your policy or the clinic's policy, the court clinic's policy you do not record these interviews, and you're not willing, and it's the policy of the clinic not to do that. Is that right?
That's accurate.
Okay. All right. So, so we're at a standstill here because, so sir, it sounds like you are insisting on having it recorded.
Can we just do the court competency while we're recorded here with everyone listening? I have no expectation of privacy.
No, sir. That's not how we do it. That's not how we do it. Okay. And I think you might have, in this case, it looks like in this case, you have previously, once before, competency was raised as an issue and you had a evaluation that was done. But, we try, sir, to treat everybody the same. So there's court rules that we try to treat everybody the same. The laws try to apply to everybody the same. The court rules, we try to treat everybody the same. So we can't make exceptions for you in this type of a situation. So,
I'm sorry, but in my experience, that's not true.
well, sir, okay, that may be your opinion about it, but in this situation, sir, I am not going to order the court clinic to record their interview with you, and we're not going to do it in open court here with court officers and probation officer and a clerk and me and the prosecutor. We're not going to do that because I don't think that's conducive to a really good mental health evaluation that would help us understand what's going on here. So,
I disagree.
Okay, I hear that. So I'm going to ask to our clinician, right now what we try to do here, an outpatient screening, meaning he's out of custody, he's in your office, maybe in the courthouse somewhere. Is there any other way that you would suggest that we could conduct this mental health evaluation? Just for, is there any other way that you're aware of?
So there are two alternatives to outpatient. Well, through the court clinic, there are two alternatives, right? One would be potentially an inpatient evaluation under Section 15B, which would be a 20-day evaluation in a psychiatric setting where he would be observed and evaluated. Potentially, if he wanted videotaping done, or video or audio taping done there. I don't know what that policy would be, so it may be the sort of the same outcome minus 20 days of observation as to whether or not there's a mental health concern that may be impacting his comments.
Okay, the other option through the court clinic is to do it outpatient is the way we tried to do it this morning. Inpatient is another way to do it, which is sometimes if we have trouble getting cooperation from the person and we have serious concerns about competency, then we can do it inpatient. So the person is held inpatient for a 20-day evaluation period at a mental health facility, and there's an evaluation done there. So that's another potential avenue, right? Now, so like I said, sometimes we consider that when the court or somebody has serious concerns about an individual's competency or ability to really participate and assist themselves in the defense of a case. So I did think about that option in this situation here, because I do have concerns about Mr. Stebbins' ability to participate and assist himself in a defense, especially as we're getting ready for a critical stage in the case, a jury trial. That's the next event here, which does require a lot of wherewithal, a lot of thinking and abilities to be able to conduct a jury trial pro se, especially someone who's not a lawyer. So some of the factors that I would consider about whether or not it should be outpatient or inpatient would be the nature of the offense and whether it's a violent offense and whether there's any history of violence or danger involved. So the offense he faces, assault and battery on a family or household member, that is a violent offense. That is, the charge is a violent offense. However, I'm looking at his criminal record, and there is a history here before the court. He's been to court before. So restraining orders, there are restraining orders here, but I do not see any convictions for violent offenses on the record. So I'm reluctant to have him held involuntarily for a 20-day period of time to do this mental health evaluation because I'm not sure that the case itself warrants, I'm not sure that him being held involuntarily for a 20-day period of time is fair or the right thing to do given the charges that he faces and the history before the court. But I do have concerns remaining about his ability to defend himself at a jury trial, which, as we said, is the next step here. So this is what I'm suggesting that we do here, sir.
Can I say this really quick, please?
Let me just suggest one thing, and then you can respond to what I'm going to propose to you here, okay? This is my proposal. You have October 15 is the jury trial date. That's the next scheduled event for the case. I don't think that we should wait until the 15th to get a determination about competency here and ability to defend yourself here, sir, because I think that we already had one jury trial day scheduled where people were thinking it was going to be a trial, but it didn't happen as a trial because there were too many things to address beforehand. So I don't want that to happen again. So, but I could not, if the case were scheduled for jury trial today, I would not feel comfortable going forward with the concerns that I have about your competency, sir, without having a clinician, a mental health expert, give some input on that. So if we're unable to do that today, which it appears today we're unable to do that because we don't have sufficient cooperation from Mr. Stebbins to do that, I think that we should have one more status date prior to the jury trial date to clarify the issue of competence, to see whether he's able and competent to represent himself before a jury. When you face, you face criminal accusations here, you face a maximum of 2.5 years in jail, so it's not an insignificant case here. So that's what I think that we should do. I think we should pick one further status date to clarify the issue of competency. Maybe he'll be in a different position by that next court date in terms of willingness to cooperate with the court clinician. And if not, then a judge can make a decision on that day about the appropriate course of action for the case. Did you want to add anything to that, sir?
Yes. When this all started, I wanted a lawyer. And I still feel like I need a lawyer.
Well, sir, that was one thing.
And I have proof that they lied to me. And the things that they lied to me about, I asked for things that I believed could be evidence.
Okay.
I wasn't positive they were evidence, and they denied me to even see or hear that evidence.
So, sir, you've had a couple of different lawyers. Here's the thing. I can see here. Right. So who is to say that another lawyer, that you would be able to work with a sixth lawyer, that the sixth lawyer would be the one who would be able to work with you?
I put all of my evidence online, so this lawyer would be able to read it. And
well, you have to. It's you. It's not. Lawyers.
And Miss Nichols' evidence, like the evidence that I'm going to use to defend Miss Nichols and why she said what she said, because I'm going to defend her. I'm not going to attack her. I understand why she said what she said, and because she doesn't even understand why I left, I haven't been able to tell her. And the entire situation is beyond either of our control that day. I don't blame her for any of this. In fact, I'm happy that it took this long so I could get back on my thyroid medication so I could think clearly and defend myself without any of the emotional issues I had when my thyroid was off back in 2021 until I believe it was August or September of 2022 that I was able to get back on my thyroid medication. And I'll sign a release for all of my medical records, too. If anyone's in question, I have no problem. I'll give it to someone in the street if you'd like to read my medical records to understand what I've been through and how I rose above all my health issues. Hence the reason there's no violent crimes on my record. Even though I do have 2 felonies where the Commonwealth tampered with evidence, and I'm just waiting on those to use these in this case because we were talking about them the day of this incident.
All right.
There's so much.
All right, sir. On the issue of counsel, so on that topic, obviously I can tell you, sir, as I'm sure it's been made aware to you, in the criminal court, everybody, if you can't afford a lawyer, is entitled to a court-appointed lawyer, which is why the court has appointed a lawyer multiple times for you. It's usually better for everybody when you face face jail time to have a lawyer because a lawyer knows the rules of evidence. But
my lawyers wanted me to attack my ex credibility instead of explaining the mental health
sir,
issues that
do
she's
you
gone
want a
through
lawyer? I mean, I think the reason that you got rid of a lawyer 3 times before, you're saying 5, I see in the file, 1, 2, 2 previous lawyers moved to withdraw, at least a third, 3 lawyers moved to withdraw.
Because of my evidence.
Saying that you did not wish to work with them.
They don't want to present this evidence to whichever judge they get. That is why. It's not because of me. I get along with I had a conversation with the psychologist and the outside. It was totally fine. We had no issues. Whether we didn't agree or not is beyond the point. But
all right, sir. Hold on a minute. Who? You know who's on today? It can't be. This is the thing that it can't be. It can't be, yeah. Right? Yeah, because I don't see, I think it was, right, O'Doherty off, Banks off, CBCS off, and McGinty off. And sir, because what you have to understand also is when you have a lawyer involved, the lawyer gets to make certain decisions about the case. The lawyer, the client ultimately makes certain decisions, but other decisions about the legal strategy, what witnesses to call, that's up to the lawyer. So at a certain point, you want to make your own decisions. You could represent yourself and have standby counsel. So that's what I'm wondering if we'll have to see what is really best for you, because I can see that you've had a difficult time working with a number of previous lawyers. But I'm wondering if anyone who's here today might be able to, what do we think? Who's on today?
Attorneys Grady, I'm writing it down for you. Attorneys Grady, Attorney Driscoll, and then TPCS.
Okay. Maybe Mr. Grady. You still live in West Warren?
no, I live at 54 Hope Street in Springfield, Mass.
All right, so let's write that. If we can write down. Are you able to write down what his current address is? We can put it on here because if we give a notice of assignment to a lawyer, they need to know his current address.
So we're going to amend his address on the docket.
Boy, that's because you live there now, sir?
I moved. The Warren address was from this incident, and that was my father's 2-family house.
In terms of where you're living now, sir.
And I moved right to Springfield, and I haven't had any other addresses either. It was just from West Warren to Springfield.
Okay.
So it's amended. Address is amended. Can you tell me the address again?
Yeah. Can you say it again, sir?
54 Hope Street, HOPE, in Springfield, Mass. 01119.
Is there an apartment number?
I'm sorry, what?
Is there an apartment number?
No, it's a residential house. It's a single.
01119?
Yes, 3
Thank you. Thank you, Your Honor.
Okay. So we'll see whether they're going to be a lawyer, full-time representation, or maybe standby counsel. If you want to be able to make the decisions, the ultimate decisions that normally a lawyer makes, and you'd really be still pro se with standby counsel. I think that's often been, based on what you're describing here, if you think the lawyers aren't doing it the way you want, it may be that the lawyers don't have to call the witnesses that you want or make all the legal arguments that you want. They get to make certain decisions about the case if they're representing you. If they're of counsel, then maybe you can make all the decisions you want and the lawyer could be there to assist you, to let you know what the law is in certain areas, things like that.
What the lawyers have told me is they don't want to do this because it opens up the Commonwealth and these other companies all these civil charges.
Okay. I'm not going to look backwards. I don't know what happened with your previous lawyer, so I'm not going to look backwards there. So this is what we're going to do, sir, to the Commonwealth. Let's pick a date that's, I don't know, something like a couple of weeks before the trial. Maybe have it put on for status on competency. And, Madam Clerk, did we have dates from Grady or?
I'll get that.
Yeah.
Is it only going to be status on competency? It's going to be 23?
Yep. 23. We're keeping it up here, because it's an East Brookfield case, really. So it's here for trial. Let's get a date from the Commonwealth and make sure it's okay for you, Mr. Stebbins, and see if Mr. Grady can be here then.
Would October 1st for the court?
1 second, I'll double check it too. Hey there, can you give me Chris Grady's dates? Hi. Can I Chris Brady speak? Yeah.
Yes,
All
October
right.
1st.
Is he there in the ballroom right now?
9 o'clock in the morning. Okay.
What day of the week is
How about-
good for him again? I forget. Thursdays? Okay, alrighty.
Can
Thank
you
The only day I have that's within the reasonable
say,
time.
can you just ask him if he could do October 1? That's what I was
He's
hoping.
in lockup.
Oh, okay.
Or in the jump. He's talking to his client in custody.
Okay.
Yeah. So I can't get to him right now. But if
But
we,
before we leave, I think we should make sure he can be here on that day,
yeah.
so
The only
we
date
can step
that
it.
I have that I know he can do is 9/27. So, yeah, if we.
How's that day?
9:27, I would be available.
How's that day, sir?
I'm not going to be able to get here until 9:30 if it's going to be the week before because I'll have to take a bus.
9:27?
Someone's vehicle.
September 27 is a problem for you?
Because October 1st is my nephew's shop week, which is a Tuesday, October 1st.
How's September 27, sir? Can you check your calendar for that day?
Well, I'm going to take a bus. I'm not going to be able to get here at 9 a.m. When the bus gets here,
On the 27th is a different day than the other days, or?
Yes, because the following, on the 27th, he's in classes. So that's not a problem, but he needs his vehicle for work, and I don't have a vehicle, so I
Okay.
have to take a bus.
Can you get here 9:27?
I can get here 9:27, but obviously.
By 9:30?
Yes.
You'll be here at 9:30?
Unless there's an accident, I'll be on the bus, which,
Okay, sir. So Commonwealth can do 9:27. Attorney Grady can do 9:27. So we can have everybody here on that day. Sir, if you want to have a trial, you're going to have to get here on that day, 9:27. If you're not here till 9:30, that's okay. We'll make sure the Commonwealth knows that, 9:30. And we'll let your lawyer know. What you need to do, sir, you've told us that you're interested in the assistance of a lawyer. We're going to give you, before you leave today, your lawyer's name and phone number. Give him a call. Reach out to him. Don't just say it's online. You can go look at everything. That's probably not the best way to share information with him. Give him an actual call and see what you can do about communicating with him about the next court date. Like I said, your options are to have him help you fully with the case, or maybe he could be on the side, like of counsel, to answer your questions. If you want to make all the important decisions about how many witnesses or legal arguments or things like that, and you don't want to listen to your lawyers, all the lawyers' decisions about things, then maybe you should be pro se and have him be of counsel so you can ask him questions. All right, those are your options with him. But you should reach out and talk to him before the 1st, okay? I'm sorry, the 27th. Did we say the 27th? The 27th, okay? And like I said, I understand one of the things you've complained about is how long this is taking. You have to keep him back to court.
it's not for me, it's for her.
Okay, so what I'm
she
saying
shouldn't have
to you.
wait for this. Either she's the victim in this. She's a victim. She shouldn't.
Okay, so I'm
she should hold
asking you to
I'll call tonight.
think about also participating, because we are not going to schedule this for a jury trial until the court, and today the court is me, the court's concerns about your competency are resolved. So if you don't like this hanging over your head, might want to consider if you can participate with the evaluation with the clinician in the way that they would like to do it. And I'll just leave it with you for that, to say that we do need to the extent that you're concerned about how long this is taking. I can't set it for jury trial before we are convinced that you are competent to defend yourself and you don't end up in a situation that would be very unfair for you. Okay?
Yeah, sure.
All right. Any other questions before we're done today?
No, thank you.
Anything else from the Commonwealth?
No, Your Honor.
Okay. 9:27, that's Attorney Grady's contact information. Okay? All right. We'll see you then.
And do they have my phone number too? Do they need my phone number? Because last time they said it. They have my address.
Who's they?
Anyone that needs to get a hold of my trial was canceled. If I had brought all those people to trial last time, they would have all been sent home. Everybody's very upset with me.
Who needs your phone number, sir?
The ADA or whoever would need to inform me if anything gets canceled, because my last thing was canceled. Nobody needs any extra information. You have all my information that the court needs.
I think we're good.
Okay, perfect.
All right. See you on the 27th.
Thank you, Your Honor.
Okay. All right. Good luck, Commonwealth. Thank you very much. All right.